Good morning, good afternoon, good evening, depending on where you may be joining us from. On behalf of the National Association for Court Management, the International Association for Court Administration, and PRAVO-Justice, I'm excited that you are joining us for an outstanding program on people-centered courts, where we will soon be hearing from leading global experts on legal design innovations in the United States, in Brazil, and in Ukraine. My name is Kevin Bowling, and I'll be serving as your moderator today. As a NACM past president and a current ICA officer, it's especially exciting to join you for this collaborative educational opportunity. At the end of today's program, be sure to tell us if you find it valuable, and perhaps we'll be able to offer you more joint sessions in the future. Throughout the webinar, please feel free to use the question and answer feature to share your questions and comments, and I'll do my best to raise your questions with our speakers as time allows. And we'll have a Q&A session near the end of our time together. So we look forward to having this be as interactive as possible and hearing from each of you. When we first started talking about providing this webinar and discussed the purpose and the objectives, we talked about innovative court design and trying to model international collaboration. And we also wanted to ensure that you leave today with examples and use cases for accessible court reforms that you may choose to apply in your home jurisdiction. With all of this in mind, as we look forward to this time together, I would like to invite Pamela Harris, the current president of the International Association for Court Administration, to share some brief welcoming remarks with all of us. Pam, the floor is yours.
Thank you, Kevin. I am honored to welcome everyone to today's webinar. I have a grand privilege of currently serving as the president of the International Association for Court Administration, and also, I too, as past president of the National Association for Court Management in the United States. First, I would like to give a shout out to Samantha Wallace, NACM's chair of their international subcommittee, who thought that this webinar today would be an excellent partnership initiative. Thank you, Samantha. The partnership ICA has with NACM and PRAVO-Justice is invaluable, and our missions are very much alike. NACM strives to enhance court management quality through continuous education and research initiatives. They focus on providing training and conducting research to support effective judicial administration. And they develop leadership skills among court managers to promote efficient judicial systems. ICA promotes collaboration through education and a world-class publication, the Journal. We facilitate the sharing of best practices and innovations to enhance court administration worldwide. And we assist with advancing efficiency and fairness in courts by supporting administrators and judges globally. And last but not least, PRAVO-Justice. Through Svetlana Mastrik's leadership, the organization promotes transparency in the judicial process by building confidence among citizens, focusing on holding judicial officials responsible for fair and ethical conduct, and aiming to increase public confidence in the justice system through various reform initiatives. All three of these organizations work tirelessly to improve court management globally and should be recognized for their steadfast commitment to justice. Now, I wish to thank our panelists, partners, and all of you in attendance for coming together in this vital conversation. Today, we have a contemporary topic that one of my colleagues pointed out. Our speaker panel cross-cuts 3 continents and 2 hemispheres, which is exactly what we should be doing. Whether you're a judge, administrator, policymaker, technologist, attorney, or other professional working in the justice system, your presence here signals something important, that you are ready to shift on how you think about justice delivery and to reimagine courts as spaces that serve people, not just processes or the institution. So why people-centered courts? For a long time, and for some of us, hundreds of years, our systems of justice have been organized around institutions, statutes, procedures, and many times precedent. These are, of course, essential foundations of any judicial system. But more recently, we have come to realize that they are not always enough. A system that works perfectly on paper, if you will, in a digitized world, can still leave people confused, overwhelmed, or excluded in practice. People-centered justice reminds us that the true measure of our courts is not only efficiently processing cases, but how effectively they meet the needs of the people who use them. This means taking seriously the actual experience of court users, especially those without legal training, without financial means, or without a strong voice in the system. A modern legal design concept is one of those most promising approaches to making this shift real. You will hear today from our three experts about their valuable insights surrounding this concept. The concept could just be redesigning a court form that self-represented litigants can actually understand and who may have helped revise. It could be a digital platform that guides users through a complex process with plain language and clear steps. It could be rethinking how a courtroom is physically laid out so it feels more welcoming and less intimidating for families and others. In short, the legal design process asks us to rebuild our systems for the people. And that brings us to today's discussion. I am particularly excited because this panel is truly international in scope, and you will learn a great deal. We will hear about innovative legal design work in the United States, where Stanford University is working with courts to close the justice gap with new service models. Creative efforts in Brazil, where the judiciary has embraced design thinking as a part of a broader movement toward judicial transparency and accessibility.
Pam, we really appreciate those welcoming remarks and the effort that you put in to join us and to make sure that some of these concepts move forward in a variety of ways across the globe. So now, as we talk a little bit further about people-centered courts, we know, as Pam mentioned, that it's an emerging and rapidly growing area of focus in the U.S. and the international court world. And we're very fortunate to have three highly regarded experts to speak with us today about the innovative work in which they are engaged. So please join me in welcoming Professor Margaret Hagan, Judge Fabricio Bittencourt de Cruz, and certified trainer Natalia Corral. We're so thrilled to have all of you here with us today. Professor Hagan is the executive director of the Legal Design Lab at Stanford University. She is also a lecturer at the Stanford University Law School and the D School, which you'll hear a little bit more about shortly. And in a moment, Professor Hagan will begin our discussion today by sharing the cutting-edge work of Stanford's Legal Design Lab. Welcome, Professor Hagan. Next, we have Judge Fabricio Bittencourt de Cruz, who is a federal judge in Brazil, although he's traveling this week and is coming to us from Barcelona, Spain. He's also an associate professor at the State University of Ponta Grossa. And in addition to his busy judicial duties, Judge Bittencourt de Cruz is a founding member of the International Institute for Justice Excellence in The Hague. He's also a regular speaker for the International Association for Court Administration, and you'll soon see that he has a great passion for people-centered justice as he shares the award-winning project which he and his students have implemented that is known as Do You Know Who You Are Talking To? Welcome, Judge Bittencourt de Cruz. And we also have certified trainer Natalia Carol, who has an impressive background in law, public management and administration, and judicial administration. Today, she is representing the EU PRAVO-Justice project, which is helping vulnerable court users in Ukraine by actively applying the principles of people-centered justice to improve court access. Welcome, Natalia. I'm so happy all of you could be here with us. And as we begin the program today, I'll note that each of our speakers will take about 20 minutes to share their work with you, and then we will open the discussion with your questions and comments. So please remember to use the chat function that's available on your screen. We'll monitor those chats as we go along. And now we're going to move things forward and let Professor Hagen take the floor and share her background and her ideas with us. I'm just going to find your slides there. There we go. And I think we're ready to get started. So thank you, Professor. The floor is yours.
Thank you so much, Kevin and Pamela. Great to see all of the panelists and participants. So my name is Margaret. I'm going to be talking a little bit today about legal design as a mindset and a process, and I'll give you some examples of how that process can both be carried out inside of a court system and also what it can create. Some of those ideas that Pamela was talking about, how to actually make real change. Next slide. So what motivates me is improving the justice system in people's lives, especially in the context of the United States, where the numbers of litigants in civil court who do not have a lawyer, don't have representation, has just been continually growing over the past decades. I think it really opens up the need for more creativity to change this system, improve it in order to make it more people-centered so it can work for people, even if they cannot afford an attorney, and that the system can be less centered on the people who created it and who run it, though obviously we care about the providers and the judges and the clerks as well, but to make sure that it works for those people who are going through a conflict and need the court's help in order to get that stability in their family, in their housing, in their finances, etc. Next slide. So I run a lab. I'm very fortunate to be at a university that has allowed me to work in a very interdisciplinary and creative way. I founded the Legal Design Lab back in 2013, 12 years ago, and we take this interdisciplinary approach, using what happens in service design, in design schools, using what happens with computer science and technology research, and bringing those disciplines into the legal system to really help us be more creative and to change our ways of how we solve problems. Next slide. Oh, next slide, Kevin, if it's possible. And one of those things that I've learned from the design school and that I'm going to talk a lot about today is moving from a priority on the system, a systems first design to the justice system, to a people first design. Next slide. And that means asking this question over and over again. This is the main question I try to teach my students to ask all the time, which is, are the things that the court or the law firms or the legal aid groups, are the things, the services, the systems, are they, for a normal person on the street, are they usable? Are they really easy to understand? Is it quick to get them? Or are they really unusable? Is it confusing and frustrating and you feel lost all the time? Are these things in the justice system, are they engaging? Do people want to come? Do they want to participate? Do they want to spend their time and energy and effort on this? Or do they want to run away and avoid, be scared, be intimidated, and not participate? And are they useful? Do they deliver value to the person? Do they help the person solve their problems, make progress, leave with a better life? These are the questions that designers ask in all kinds of fields, not just in law. Do we make things more usable, more engaging, and more useful to people? Next slide. And how do we think about understanding how to answer those questions, but also coming up with ideas to make the system more useful, more engaging, and more usable? The design approach is not just about asking that question, but also coming up with ideas. And this means changing the way we work sometimes as people, as lawyers, as court officials. It's about talking to people, and I'll show you some examples of that. It's really engaging with different members of the community to hear from them, to hear their ideas, their feedback, and working alongside them as we come up with new ideas, whether it's new ideas for how to communicate on pieces of paper, on forms and notices, or what kind of digital or technology things to create, or how to lay out the space, how to set up these services or new programs. It's actually involving our stakeholders in the process to hear from them and make sure that what we're creating will be usable, useful, and engaging for them. It also means a shift in how we develop new initiatives, that it's not just about laying out a memo of a plan and executing that. Really, it's about a commitment to continuous learning, that we're always getting feedback and using that feedback from users and other stakeholders to make our things better, make our technology better, make our forms and paper better, make our services and programs better. But that commitment to continually getting feedback and using that feedback for improvement. Next slide. So at the Legal Design Lab at the university, we get a chance to try all different kinds of methods, both to hear from our community members about what's going wrong and what's going right, as well as coming up with those new ideas and going through that continuous learning of testing. So we teach classes all the time in which we're partnered with courts or legal aid groups or local governments to do a lot of this research and go out and talk to people and understand where there are breakdowns right now and where there's opportunities for new innovations. Next slide. The first main thing we do, and I'll show you some examples of how we do this, is really trying to understand the points of view, the experiences of litigants, of court users. Next slide. So one thing we do with our students and with our partners is just talk to people. So in the hallways, outside of the courtrooms, as people are waiting to go in, or as they are coming out from their court experience, we ask them, could we talk to you for 5 minutes, 20 minutes, if you have the time, even 30 minutes? Can we hear, what were your expectations for today? Why did you come to court today? What were you hoping to get out of it? How did it go when you were with the judge or the clerk or the other court staff member? What was good? What was bad? Do you understand what just happened? How could it be better for you? What do you wish this experience was like? We can learn a lot in even just 7 minutes of chatting with a person to hear both what their barriers are, whether it's around language, around the intimidation factors of coming and dealing with a high stakes government thing, whether it's about lack of clear information or things online, but we can really spot the barriers very quickly. And also they often have a lot of ideas, even some small, easy things to change that could have made them more prepared, have their expectations better fit, and to kind of improve the experience for other people. Next slide. We also do a lot of observation. So thanks to our partnerships with courts, we can kind of sit and be a fly on the wall, whether it's like in a self-help center where people are trying to fill in forms, trying to hear what the process is going to be like, And you can hear where people are getting stuck, where they are getting frustrated, how they have tried and what's failed. But you can very quickly find pain points as you observe whether sitting in the hallways outside of courtrooms, in these help centers, even as people are waiting in line. There's full of data and insights about things to improve. Next slide. We also walk in the shoes of litigants, and I highly recommend this, even if you are a senior court official, a judge, otherwise. Try to walk through the courthouse as litigants do, waiting in line to see the clerk, trying to fill in the pieces of paper, sitting in the waiting room, feeling anxious before the trial is about to begin. It's very helpful to actually know what are all the steps that a person has to go through in order to navigate the court system. What feels frustrating, what feels confusing, what's actually easy and really supportive. But you can start to see all of those different good and bad touch points that a person has with the court. Next slide. And what we ask our students to do is, after they do a lot of those interviews, observations, and walking in the shoes of a litigant, we can start to make a map, what we would call a user experience map or a journey map. Here are all the stages that a person actually goes through, even about going through security or trying to find the right room. Here are the feelings the person is going through. Here is where they're good and feeling confident and empowered. Here is where there is breakdowns and where they need a lot more support. Next slide. And each of those moments along the journey map, we can make into what we call a design brief, which is basically an opportunity for a new initiative, a new innovation. Could we help them before court? Could we help them right as they are coming into the courtroom or courthouse? How do we help them as the court is letting them go from the trial? All of these become kind of brainstorming moments where we can say, here is a key point where we either need new paper, new technology, new programs, but we need something new here because this is where there is a breakdown. Next slide. And that is where we get to our second. So in all of our classes and engagements, we do all of this kind of diagnostic research. Where are there opportunities and problems? And then we go into the second phase of brainstorming and creativity. What could we come up with? What are ideas? Next slide. So we do a lot of brainstorming about what if. Here is a sample courtroom. We heard people really frustrated in this hallway. What if we made a map on the wall that would explain exactly how the process works? It's not like we're going to do that right away, but let's come up with some ideas. How could we make this better? Next slide. Or let's map out the process. We have learned exactly all the steps that a person needs to go through in a court journey. What are all of our ideas at each of those stages to make them better, make them more usable, more friendly, more engaging? Next slide. We can also invite the community in and ask them, we heard from many other litigants that this was a problem. What ideas do you have? What would you want if you had a big budget, or if you were in charge? What would you make? Would you make a new technology app? Would you make a new program in the courthouse lobby? Would you change where the court is? We do lots of brainstorming activities where we get ideas from different stakeholders. Next slide. And then we start to make those post-its of ideas into what we call prototypes. So it could be a poster, it could be a simulation, but it's a very, I would say, cheap and easy first version of an idea. And we invite the litigants in to tell us which idea is good and which idea is bad, but start to get that involvement of them making the choice about what new initiative we might launch. Next slide. We often invite big groups, like a focus group or a discussion group of stakeholders together, and we present out, here are the top 10 ideas we have been hearing. We want your votes or you to discuss which of these is the most valuable, which of these would be the most impactful. to decide which of them should actually be piloted. Next slide. And we have kind of ongoing testing. So even as a pilot is launching, to always be inviting the stakeholders back in to give us feedback as that post-it of an idea starts to become more of a robust formal pilot. Next slide. So let's talk a little bit about what actually comes out from all of that user research and then creative brainstorming. Let's give some examples about what comes out of that. Next slide. Oh, I forgot. First, it's about why we're doing this, then the examples. So one motivation about why we take this approach is that we really want that justice journey that a person goes through, whether it's around their housing, their money, their family, etc. We want them to have a sense of fairness and dignity, procedural justice. We also want them to get a fair outcome, but that journey really matters, and it touches on their whole relationship with their government and kind of civic institutions. Next slide. We also realize that because of how confusing and hard to use the justice system is, many people feel a lack of dignity. They do not feel they have control of their life or control of their conflict. And we really believe that by increasing the usability and the people-centeredness of justice systems, it can really restore dignity to people who are often in a crisis. Next slide. And we want them to be able to have legal capability, that as kind of an equal citizen or resident of the jurisdiction, that they can understand the law, they feel the law is for them, and that they're able to use this legal system on an equal footing to everyone else in society. We really believe that fundamentally. Next slide. And it's all about kind of having the justice system be a place where people feel heard, they feel they're capable, and they feel that they get a fair, just outcome and experience. Next slide. So now let me get to some examples of what we actually make. Next slide. So one example, and this comes from a partnership that we have with LA Superior Court in Los Angeles. We work a lot actually on pieces of paper. We work on how the court lays out information on notices, summons, forms, and other lawsuit paperwork. So for example, here is the piece of paper on the left that the Los Angeles Superior Court sends out to all defendants who have just been sued for an eviction. A very important piece of paper, crucial information, a summary proceeding, so only 10 days after you get this piece of paper or the lawsuit to file a very important answer. We heard from so many litigants and court staff that this paper is not doing its job. It is not usable. It's very confusing, full of information. Often people are calling the wrong phone numbers, not able to understand what's happening, not know what to do. But it's a very important piece of paper. It has so much potential. So we have spent almost a whole year with lots of different users, advocates, and court staff, judge officials, to remake this piece of paper to both be legally compliant, but also to be much more actionable, understandable, and living up to the potential to what it's supposed to do, which is make sure people know that they have a very pressing lawsuit, but they also have options. Here is how to get a copy of your lawsuit. Here are the places to get help. Here is the deadline by which to respond, making all of that very important information more salient and hopefully more actionable so that more people will participate in their case and be able to actually take a strategic next step. Next slide. Another thing that we work on a lot is the actual layout of the court, especially wayfinding to actually know where to go once you make it to the right court building, helping people find the right court building. When there's a very time-sensitive hearing they have to be at. And then once they are in the space, that they can find the right room, and the hallway as a key place where people are learning. We keep hearing that people learn so much in the hallways. That is where they are really tuned in and really eager to build their legal capability. So they are talking to other litigants, they are talking to lawyers, they are talking to court staff, they're talking to bailiffs and security officials. So how do we make those hallways a really key place where people can learn and build their capability? Because that's what they are very excited to do when they are in the hallway. Next slide. We do a lot on the actual service and program design. So what are the options available to people? How do they go through this journey? And that's about designing new programs, like new diversion programs or assistance programs or self-help centers, to reach out to people and then take them along a service journey so that they leave more capable with correct forms, filed correctly, all of those things. Next slide. We do a lot of guide design, whether that's pieces of paper or posters, things to hang on the wall to help people understand the process or understand their rights. Next slide. Another example, walking people through, here is your right, and here is how you actually fill in the papers to make this claim. Next slide. And we do digital versions of guides, not just posters and handouts, but also websites or apps that can walk people through step by step how you file for a protection order in Virginia, how to do this very clearly with lots of pictures and lots of details. Next slide. And we do that also not just through websites, but through text message. We hear so much that people want low cost, easy to use text messages to get reminders, to get the next steps to do, or even something that looks like coaching about how to file the piece of paper, show up to court in the right clothes, come at the right time to the right place. Next slide. And we're also starting to work on AI solutions in a very careful, human-centered way, but to help people spot what their legal issues are, match them to resources, and prepare legal documents. Of course, we have to be very careful with this, but there's a lot of excitement, so we're exploring what that future of AI-powered help looks like. Next slide. So I think I'm going to close out here. I'm just going to say there's a wonderful network of people working on these improvements. Next slide. And if you're interested, the Access to Justice Network, which is hosted at the Legal Design Lab at Stanford, is an international community of justice professionals, all of whom are working on making a more people-centered justice system. So I urge you to come join us, no matter what your role, but there's a wonderful list host and community of people who are all working in the same way. Next slide. And I'll say thank you. Thank you so much. And I'm looking forward to the other presentations and then Q&A.
Margaret, thank you so much. That was a great way to get us started. Lots of good information on things that, are easy and straightforward to do. They make sense. And it's kind of fun watching the screen. You're getting lots of hearts and lots of applause. So I think you hit, the critical part of, where do we start? How do we begin this? What kind of questions do we ask? And now we're going to switch gears and have Judge Fabricio Bittencourt de Cruz tell us a little bit more about how he's picked up on some of your ideas and is working on projects with his students and with the courts in Brazil. And for this, Judge, I'm going to stop sharing my screen and let you go ahead and pull up your slides. And you should be able to do that now.
Okay, Kevin, first of all, I want to say thank you, Pamela, for this opportunity. And I was remembering the first time that we talked about this webinar. It was in Singapore last year, November of 2024, and I'm very happy and honored to be here today to make this webinar happen. And I'm also happy to see you and Pamela again in Dubai next month. So let's start sharing my presentation here. Just tell me, Kevin, if you're seeing
I can
Okay.
see it now. You're good to
Okay.
go.
Okay. Today, I'm really excited to share an experience of applying legal design and visual law within the Brazilian judiciary system. This story revolves around a collaborative project developed at the first instance of a Brazilian federal court involving four people: a federal judge, myself, two public servants, and an intern. And the servants were João Leandro and Karina, and probably Karina is with us watching this webinar. So Karina, you, João Leandro, of course, our intern Elena, were great partners in this project. So I want to say thank you, Karina, thank you, João Leandro, and also thank you, Elena. We are a very powerful team working together. This project's concept originated from a role as a law professor at the State University of Ponta Grossa in Brazil, where I lead the project Mind the Gap, a collaborative, academic, and scientific initiative that bridges law, innovation, and technology. And that's the reason, Margaret, because I really think that we have a huge connection here, because we found this Mind the Gap group in 2017, deeply impacted from your perspective on your lab in Stanford, United States. Mind the Gap has 5 areas of research which converge on a central theme: optimization of access to justice. The word optimization perfectly captures the essence of Mind the Gap. Optimus in Latin means achieving more with less, accomplishing more, better, and faster. We conduct both theoretical and empirical research on topics like artificial intelligence, blockchain, and also smart contracts, known as hard skills because mastering them requires long academic and professional dedication. But we also focus on soft skills, providing knowledge in plain language, legal design, and visual law. These skills are easy to replicate with low operational costs, making them ideal for training public servants in the judiciary to develop innovative solutions. From the academic and scientific perspectives of Mind the Gap, we recognized the potential to introduce an innovative mindset in the Brazilian federal court, a shift we call embracing soft skills. To make this shift happen, we rely on design thinking as our guiding framework. It bridges the gap between law and design, tradition and innovation, rules and creativity. For this talk, I've highlighted 4 key traits of design thinking. The first is problem solving orientation, the ability to identify, analyze, and develop solutions for complex challenges. The second is human-centered approach, which places the user's needs, desires, and context at the core of the design process. The third is empathy, the ability to understand and emotionally connect with users' needs, thoughts, and feelings. The fourth is co-creation, which brings in users, stakeholders, and various participants to the design process. This collaboration enriches and informs the solutions developed through design thinking. I'd also like to introduce 4 key stages in the practical application of design thinking. The first stage is inspiration, the spark that drives innovation and creativity in the design process. The second stage is prototyping, where we create early models or preliminary solutions to test ideas and concepts from the very start. The third stage is iteration, a process of refining designs based on continuous feedback and learning. And the fourth stage is ongoing validation, a constant cycle of testing and improving solutions based on real user feedback. In our academic and scientific work, we've shown that design thinking and legal design are not only technically feasible, but also legally sound in Brazilian law. They help make legal outputs more visually accessible. But we didn't stop there. We took this a step further, proactively addressing the challenges of the Brazilian judiciary through the lens of optimizing access to justice. After all, big challenges create big opportunities for innovation. While the Brazilian justice system shows efficiency in terms of cases judged each year, this hasn't been enough to handle the constant influx of new cases, leading to a growing backlog. One of our Constitution's core principles is wide access to justice, or the broadest possible access to the justice system, with significant social challenges and barriers preventing much of the population from accessing the judiciary. This is a principle we simply cannot compromise. In 2023, the cases filed reached 37 million, while Brazilian judges resolved 36.5 million cases. The number of new cases exceeded those resolved, leaving us with a backlog of 84.3 million cases. Undeniable. Our greatest challenge, Kevin. To offer a more dynamic perspective, here's some recent statistical data from the Justice in Numbers report by the Brazilian National Justice Council, Margaret. On this chart, we see the annual number of cases entering the judiciary, with about 27.5 million new cases in 2020, rising to 36.9 million in 2023. The upward trend is clear. The second chart shows the number of cases resolved by the Brazilian judiciary from 2020 to 2023. On the right, a scale ranging from 25 to 40 million highlights the increasing efficiency and outcomes achieved by Brazilian judges. Our main challenges are evident in this third chart, which compares new cases with those resolved each year. While judges' efficiency has improved, as shown in the darker green tones, the number of new cases has consistently exceeded those resolved. This pattern has persisted for the past 20 years, with new cases each year surpassing the judiciary's capacity to keep up. This fourth chart highlights the increasing backlog from 2020 to 2023. The backlog grew from about 82 million cases in 2020 to around 84 million in 2023. This macro scenario clearly underscores the urgent need for bold solutions that move beyond the traditionalism anchoring the Brazilian administration of justice. In response to this scenario, we designed, developed, and implemented a project to optimize access to justice through legal design and visual law. This initiative specifically targeted criminal procedures in the first instance unit of the federal justice under my responsibility as a federal judge. The focus was clear: reduce operational costs and deliver greater value to the community. Our project aimed to increase efficiency, streamline workflows, raise judicial service standards, and improve citizen satisfaction with judicial service, Margaret. It all started with a key realization: communication in criminal cases needed to improve. When someone was convicted, the legal complexities in summons orders and any monetary hearings often made it difficult for citizens to fully understand what was expected of them during sentence compliance. After 18 months of empirical and scientific study by the Mind the Gap team, we discovered that summons orders failed to clearly convey what convicted individuals need to do. People attended admonitory hearings without a full understanding of their responsibilities, and And even after these hearings, many were still unsure of how to fulfill their sentences. It's important to note that both the summons orders and the admonitory hearing are procedural acts in Brazilian law. They serve to communicate the final criminal conviction, explain how the sentence should be served, and warn about the consequence of non-compliance. Communicate, explain, and warn. The project was built around two main objectives. The first one was to improve communication in summons orders for individuals convicted in criminal cases. And the second was to eliminate the need for admonitory hearings. Our initial hypothesis was simple. By integrating legal design, visual law, and plain language into the summons order, we could enhance communication with convicted individuals. This would make the admonitory hearing unnecessary, as the summons itself would effectively communicate, explain, and warn. Three essential principles guided the project: simplicity, replicability, and adaptability. The process had to be simple, clear, and accessible to everyone involved. Replicability meant that other units in the Brazilian judiciary could easily adopt the guide, and adaptability ensured that the project would evolve and improve with future updates. This vision led to a project with title, Do You Know Who You Are Talking To? The name carries deep meaning. We realized that the language in our summons orders was essentially a message between the judge and the bailiff, not between the judge and the convicted citizen. We needed a way to make this communication more direct, simple, and accessible, creating a clear connection between the judge and the person required to comply with their sentence. This shift changed how we saw the summons order. It was no longer just a document to be delivered, but an optimized communication platform for the convicted system. From this powerful insight, this visual law guide was created. We created this guide to go along with the summons orders, providing clear instructions for the sentence compliance. While the instructions are in Portuguese, the guide stands out for its thoughtful design elements like typography, layout, icons, and visual language. Every detail was carefully crafted to make this format unique. On the second page, we included a question and answer section along with a QR code. This QR code provides access to an additional instructional tutorial, offering even more clarity. This approach, combining plain language with visual delivery, is consistent throughout the entire guide. This project is the result of collaboration between 4 people from 2 generations, blending legal expertise and maturity with youthful creativity to achieve this outcome. Moreover, the project aligns with the Brazilian judiciary's macro challenge for the next 6 years, as outlined by the National Justice Council. By integrating plain language and innovative methodologies, it aims to improve efficiency across our judiciary. As a result, the project eliminated the need for admonitory hearings, a procedural act that was often inefficient, time-consuming, and costly. The project has an external validation and is being used by several other units within the Brazilian federal justice. It was already being updated to new versions, tailored to fit the specific needs of each unit. This initiative has also achieved significant cost savings in the federal justice unit where it was first implemented, reducing expenses by around 900,000 Brazilian reais annually in public and private resources. If adopted by all criminal units within the Brazilian judiciary, it could save close to 1 billion Brazilian reais per year, about $200 million per year. Beyond the measurable results, there is an intangible outcome, a cultural shift in the unit where we implemented this project 3 years ago. For me, this cultural change is the project's greatest achievement. A culture of innovation has taken root. Public servants now feel empowered to unleash their creativity, propose solutions, and test new ideas. This is why I was eager to present this project as a case study, highlighting this cultural shift as its most significant impact. Naturally, we face some challenges. We trained public servants in design thinking from the ground up. Some hesitated, holding on to traditional mindsets, and a few lawyers questioned whether the guide was the best solution. In a recent survey conducted by one of my doctoral students, Gabriele, she probably is with us today, just about 5% of lawyers indicated a preference for the admonitory hearing model. Because of this, a hybrid approach is recommended, holding admonitory hearings in cases where traditional minded lawyers see them as a better options. The most important takeaway for all of us here is this. Design thinking, legal design, and visual law are not just effective, they are shareable, teachable, and really transformative. As a professor, I have the privilege of passing these soft skills on to my doctoral students. I teach and apply these methodologies as practical tools that are meant to be shared and expanded upon. In my course, Legal Design and Optimization of Access to Justice, the projects my students create consistently deliver remarkable results. Let me share a message from one of our project participants, our intern Elena. She wrote, just stopping by to say thank you for being part of this incredible project. Interning at the Federal Justice, a dream coming true, and having the opportunity to work with you all has certainly already changed the course of my future. I'm here today not just to share this story, but to bring an important message. Design thinking, legal design, and visual law are fully applicable for optimizing access to justice. I came here as a witness to show that these methodologies offer a set of soft skills that are quick to learn, easy to share, and capable of transforming judicial systems around the world. So thank you so much.
Thank you so much, Judge. That was great. You're getting a lot of fabulous responses and applause from our audience here. There was an interesting question that came up that rather than waiting till the end, Margaret touched on this a little bit in the beginning, and you included it, where you talked about visual law and some of the visual communication things. The question that came from Eric was, what do you mean by visual?
Myself or Margaret?
Yeah, yes, please go ahead, Judge.
Okay, here in Brazil, we understand that visual law is everything that you can do to make your communication into the process better. You can use just plain language, or for sure using shortened paragraphs, soft language. You can use charts, you can use videos, you can use everything that improves communication. The purpose is a better communication, so visually is better, but a text is also visual, depending on how you create it.
All right. Margaret, did you want to add something to that as well?
I think Fabio said it perfectly. It is so much about just thinking about how things are laid out. and really looking at the papers, the screens, the signs on the wall, just looking at the visuals around you, text included. And the question is, can people engage and understand with it? And how do we make that better? So it could be laying text out in shorter pieces, more plain language, boxes or bullet points. It does not have to mean everything becomes images or videos, though of course have that in your toolbox.
All right. Very good. Thank you so much for that. We've got other questions that are going to be coming, but I wanted to touch on that because it seemed to be an issue that both of you raised in your presentations. But what I'd like to do now is to shift gears and move on to Natalia. Thank you again for your patience and for waiting for us, but we're anxious to learn about the Model Courts Initiative that's supported by PRAVO-Justice and how you've experienced that in Ukraine. So with that, Natalia, I'll turn the floor over to you.
Thank you. Greetings from Ukraine. First of all, thank you for your kind invitation to speak today. It's my honor to represent, to share with you the story and great, to my mind, achievements of the Model Courts Initiative in Ukraine. It's a project which has helped to transform justice way is delivered in Ukraine. The Model Courts Initiative, it's a huge project supported by European Union through the project PRAVO-Justice, and it has become a real driver of changes in Ukraine and building more people-oriented and efficient court system in our country. So let's start. The initiative began in 2017 when the UE launched the PRAVO-Justice project in Ukraine, and the clear goal was to improve judicial reform by improving the quality of judicial services and strengthening the court management. And from the beginning, the focus was on the people who use the courts, on user orientation, professionalism, efficiency, and safety for both court staff and court visitors. It focused on rethinking how Ukrainian courts function, not only as institutions of justice, but as service-oriented organizations. And from the very beginning, the initiative was driven by collaboration between the judiciary, court staff, and international experts. Next slide, please. 2020 came and it was the year of challenges and adaptation. Despite the pandemic, our initiative didn't stop. Instead, it went online, and a significant part of the initiative's activities was conducted using new online tools. And you see, as a result, over 2,500 judges and court employees actively engaged in the different online trainings and events, proving that our system can stay open, modern, even in difficult times. Next slide. In 2021, our initiative even grew stronger. And this year, we created an online platform of good practices. This platform engaged more than 70 courts which joined the network, and other Ukrainian courts could exchange their experiences, their different experiences, and learn from each other in areas like communication, client-oriented services, services for vulnerable people, IT solutions, court security, and court management as well. And we built a huge community of professionals committed to better justice. Next slide. I have to say a few words what makes the initiative special. It's a real special initiative because it offers real practical tools that make management easier and services better. I mean manuals, volunteer service, modern designs, and standard procedures. It helps our courts use their resources wisely. And with strong support from the European Union and other partners, it has built a reputation of trust and quality. Next slide. The initiative focuses on 6 key areas: client orientation, court administration, court security, working with vulnerable categories of court visitors, communication, and human resources management. Next slide. Let me introduce a few results, only a few results. During this initiative, we trained hundreds of trainers and volunteers. We developed practical manuals, introduced safety and first aid training. Also, we created new ways to support vulnerable court users. Altogether, more than 100 module solutions have already been implemented in Ukrainian courts. A clear sign of progress to my mind. Next slide. Our initiative, thank you. Our initiative also focuses on our courts' everyday solutions that matter. Now, courts in Ukraine run awareness campaign, launch volunteer and support services, create child-friendly spaces with green rooms and comfortable waiting areas. Most of these changes require little or no extra funding, just good ideas and a teamwork. Next slide. The Model Court initiative shows that reform can be both practical and sustainable. Its solutions raise the quality of court services, make justice more accessible, and respond to the needs of every visitor, including vulnerable people. It's also the first initiative that unites best practices from many international partners, all working together for one goal: a better court system. Next slide. Oh, one of my favorite slides. Volunteers became an essential part of the Model Courts network. 18 pilot courts across Ukraine engaged over 300 trained volunteers, working alongside staff to assist court visitors. Partnerships with universities and legal aid centers helped establish formal cooperation through memoranda and mentorship programs. These initiatives strengthened community involvement in the justice system and highlighted that access to justice is a shared responsibility. Next slide. A model court is more than modern building. In Ukraine, it's a place of trust, client-oriented, safe, inclusive, and efficient. And the main idea that courts value its people, invests in their growth, and deliver fast, high quality, and fair services. You know, that is the court of the future, but it's already taken shape in Ukraine. Next slide. And the next one, recommendations for further implementation. Looking ahead, the initiative solutions continue to demonstrate their sustainability. They improve services quality without requiring additional funding, the main, a vital factor for long-term impact. The focus on user needs, inclusiveness, and efficiency ensure that every court can implement these real practices, regardless of location or size. The platform of good practices serves as a foundation for continued learning and innovation, allowing courts to exchange experience and maintain progress beyond donor support. Next slide. The Model Court Initiative is unique in that it unites the best achievements of different projects under one framework. It strengthens HR policy, encourages staff development, and helps courts build their own professional brand. More importantly, it creates a comfortable, client-oriented, and safe environment where justice is not only delivered but also experienced with respect and trust. These characteristics have made the initiative a model of effective judicial reform and a source of inspiration for further projects in Ukraine. Next slide. And good news that even nowadays, in 2025, the story continues. Model Courts Initiative continues to grow and evolve. Today, more than 150 courts across Ukraine have joined the network, proving that the model approach is not just a project for us. It has become a national standard for quality court management. And this year marks an important milestone: the sustainability of the initiative through the work of the All-Ukrainian Association of Court Employees. Together with European Union project PRAVO-Justice, we continue to implement new standardized procedures, from services for vulnerable groups to court conflict management, and even standards for the use of artificial intelligence in courts in Ukraine. These steps ensure that the values of client-oriented justice, professionalism, and innovation remain at the heart of every Ukrainian court. Honestly, we want to develop this program further, especially considering that as a result of Russia's war against Ukraine, all Ukrainians are vulnerable today. And with thousands criminal investigations in war crimes opened by Prosecutor General's office, unfortunately, there will be more and more vulnerable users. Next slide. In conclusion, the Model Courts Initiative in Ukraine is about more than procedures. It's about people, values, and service. It's about making sure that everyone who comes to court feels respected, understood, and supported. Thank you for your attention, and thanks a lot again and again for your invitation.
Natalia, thank you very much for that. That was a great description of this Model Courts Initiative. We're so happy that you were willing to share that today. And, you know, you just touched on it briefly and didn't say a lot about it, but I'm sure that there are a lot of folks that are on the webinar today, especially here in the US, that are concerned about the courts in Ukraine and are wondering how you are dealing with operations in the midst of a war. And, you know, most of us have never been in that type of situation. And it's quite impressive to see what you have accomplished and the fact that you've done a lot of this with volunteers that have come forward and help out. Is there anything else you'd like to share with the audience about the experience that you're going through there?
Thank you. Thank you for your presentation and question. Honestly, it's not so easy to work in conditions of war, but simultaneously we try to make our courts more people-oriented because of vulnerable people and increasing vulnerable groups as court users. And if we say about volunteers projects in Ukrainian courts, we implemented this project some years ago. We try to involve students to assist our court staff and to reduce the workload for our court staff and make our courts more people-oriented.
Very good. Thank you for that. And now as we move into some of the questions and answers time that we have, I'll invite Margaret and Fabricio to come back on screen again. And we have an interesting issue that was raised by Lisa, who wanted to know from each of your respective projects or in general, what strategies do you find best for involving general court users, both in needs analysis and in assessing the outcomes for initiatives like the ones you've talked about today? And maybe I'll just go in order of the presentations, and Margaret, invite you if there's anything you'd like to share first.
Definitely. So there's I think lower resource options, like less money and less planning, to more intensive ones. So the easiest ones are literally the hallway intercepts or the coming into court. There's lots of court users in the court every day. That is a particular type of user, though. It is someone who has made the effort and done a lot of work to get there in person, or the person who needs the more in-person help rather than digital. So knowing with those caveats that you're not getting a full representative sample of the court user population, those kinds of stopping people in the hallway, asking them if they have a little bit of time to chat or fill in a survey, very, very low energy needed, and especially with a partnership with a university where they have lots of prep work on how to do that in the ethical way, how to make sure there's clear consent, and possibly even compensating users. That's where I think university partnerships can help a court a lot to do those kinds of intercepts. The more intensive ones are recruiting people from a particular case type or with a particular kind of diversity of demographics. Those often tend to be past litigants. So litigants whose cases are now closed, but you want to hear their full journey and understand a representative sample of users for a divorce. That's where the court can do a lot to help reach out to past users, or universities or other groups can do advertisements and outreach to bring those people together. That takes more planning and more resources, but it can be a fuller picture of different court users.
Good examples. Thank you for that. Judge, what types of strategies did you find helpful in getting folks to engage with your project?
We're trying to make three kinds of approach, Kevin. The first of all is report experience. Report and spread the experience, because people really need to see and know what is happening in each unit within innovation in legal design or visual law. So the first step is spread the news. The second one is share the products, share the concepts, share the products, share the prototypes, so other units can use or iterate your first approach. And the third pillar is to make qualitative research after the implementation of each project. We're making this kind of qualitative research, interviewing and knowing what the people feel about about each individual project after the launch or after the first or second or third iteration. So spread the news, making reports, share your models, and make empirical and qualitative and scientific analysis to prove that one kind or other kind of approach is better than others.
All right, thank you for that. Natalia, it appeared as you went through your presentation that you relied more on court staff, court employees in this. Did I get that right, or did you also have some strategies to reach out to the community?
I just listening and thinking about it. Ukrainian courts have some recommendations from High Council of Judges. We have a Council of Judges decision, so Ukrainian courts are recommended to assess once 3 years to assess the quality of judiciary, and we don't have one strategy. We try to use 2 ways to assess. The one way to involve NGOs. We involve NGOs to make the assessment, and during Model Courts Initiative, we try to involve students to make some survey, to make some interviews, but I have to say that court users don't like to take part in the survey and these interviews, and we try to use the alternative method to make this online on our website through the QR code, and to gather all information, what they'd like to improve, what they'd like to make better by courts.
Very good. I think you saw all of us smiling when you said that sometimes the court users don't want to participate. We've all experienced that in one way or another, either through direct contacts or surveys or phone calls or
it's a challenge for us also.
We can feel your pain in that regard. I've got an interesting question, somewhat philosophical in my mind, from Ethan, who asks, what is the process that you use for weighing the real need for courts to be more accessible and people-oriented against the need of the court to remain neutral, a neutral place for people to seek resolution of their cases? And I've just opened it up to any of you if you have some thoughts about that. Margaret, please go ahead.
So I think in my presentation, of course, I talked a lot about the litigants and the users, and that's true. We do so much work with them, but the other key part to any legal design project where the court is going to be the new innovator or holding that initiative is to make the process multi-stakeholder. So it takes more time, but it means that you're having all of those voices in the room. We as the lab go out and we talk to the people and we find their needs and their proposals, but it's not like those proposals get immediately greenlit. No, they go through a lot of feedback where we have repeat advocates, meaning legal aid lawyers, plaintiffs' attorneys, paralegals, talk about which of those ideas are feasible, legally compliant, etc. And we have the judges, the court administrators, the frontline clerks and hotline staff also say what they are dealing with behind the scenes, what their obligations are, both kind of ethical and regulatory or statutory, budget-wise. So we have a lot of iteration that goes on from all of those different stakeholders' priorities. And that neutrality is obviously a key constraint in the system. And any new idea that moves forward has to operate within that. But we tried to kind of do that iteration from these very ambitious people-centered ideas that then have to get refined so that they are ethically compliant, legally compliant, and work for everybody in the system.
Good. Judge, please go ahead.
For sure, Kevin, I will answer your question from a Brazilian point of view. So probably neutrality makes sense to you as a different way, which makes sense to me. But for my perspective, independence is the key. A judgment, a resolution of conflict made by the judiciary had to be independent. And in my point of view, and from our perspective in Brazil, we have huge differences between knowing the system, between the ability, the capability to really know what's happening inside a process, what's really happening in the legal system. So our approach on legal design or visual law is embracing the it's trying to make more easy to understand what we make into a process, not dealing with not making our judgments less independently. I'm not sure if I make myself clear, but the main perspective is independent is the key, and the way how we deliver our answers, our process, and our informations had to be more capable of achieve each person, each citizen, independent of their capability of understand the legal system and the process itself.
So, Judge, let me press you a little bit further on that. I'm fascinated by your response to that and the concept of where neutrality and independence merge and come together. You have been working for some time on these visual law and access to justice issues and people-centered justice. Do you think that your experience with your students on some of these projects has made you any less independent as a judge, or has it enhanced your independence?
Kevin, it's a very important question because you gave me the opportunity to talk about empathy. Definitely, the project, the MindGet project, which which had begun in 2017 with just 17 people, and nowadays has 200 people spread around Brazil. As a result, I become a more empathy person dealing with the cases, not less independently. I can keep my independence, but I have more empathy thinking about the delivering of our texts, our sentences, our orders, and our communications. That is empathy is the result of making this legal design and visual law approaches on the last years, deeply because of the collaborative approaches in our project.
All right, very good. Natalia, can I ask you, from your experience in Ukraine with this model court initiative, do you feel like it has strengthened your judges' abilities to be independent and neutral in the court? Or has it not had an effect there, and it's more on the court users and making the courts more accessible for them?
Thank you for your question. As a chief of staff, as a court administrator, I'd like to say that court staff can also make better feelings for court users in the courtroom, not judges, but court staff, because the first contact you have in the court not with judge, but with court staff, with servants, with civil servants. And Model Courts initiative focuses on the main idea that court staff, through the transparent procedures, makes a feeling that court is unbiased and fair. And the courtroom procedures, so the procedures in the courtroom, you feel like a judge and court staff unbiased, all of them unbiased, and doesn't depend on the last decision. in their cases. So model courts initiative try to involve civil servants, court employees to help judges to be unbiased and empathy and make a positive imagination about courts in Ukraine.
Excellent observations. I appreciate all of those. We just have maybe time for one more question. Nicholas asks, he says, I know technology was mentioned multiple times throughout the webinar. Within our jurisdiction, we are in the process of preparing an e-record where all court records will be digital in the next decade or so. While useful from a staff perspective, are there any suggestions on how to increase engagement between a user and available technology resources? I don't know if Judge and Margaret, you both touched on AI and using AI. I don't know if that may play into Nicholas's question. Please go ahead, Margaret.
Yes. So I think we're in an era of lots of technology innovation, which is exciting. But often what I see happen is that people-centeredness gets lost to technology-centeredness because we're so excited about a new e-record or case management or AI solution. We need to always go back, even though keeping that technology excitement, to say, what is the problem we're trying to solve? What is the touch point or the thing the person is trying to do? Whether it's what the court staff member is trying to do, screen an incoming lawsuit for deficiencies, or is it the user trying to understand exactly what the lawsuit against them is alleging? But what is the person's problem that we are trying to do? And then making sure we understand that really well and understanding where the person is. Are they in their office with multiple screens? Are they hunched in the hallway with a bad data connection on their phone? But how do we make the technology work to solve that person's problems within their setup and constraints?
Yeah.
So all excitement about technology, but always remember to center it back on the person.
Yeah, I understand that. And, you know, I think we could probably have a whole session just on technology and how it deals and interacts with people-centered justice. But unfortunately, we've hit our bewitching hour. We're at the bottom of the hour now. I hope that our participants will take some of these key insights away from all of your great presentations today. That there are ways to do this, that it does involve collaboration, which all three of you are a perfect example of coming together and sharing these ideas and collaborating on these today. Obviously, the judicial transparency is an important part of it. And Judge, I'm so happy that you made that point about independence. I think that needed to be part of this conversation. So I think it was very helpful. And I see that our president has rejoined us. Pam, do you have any closing comments that you would like to share before we wrap up today?
No, I won't take anyone's time up other than to really thank our panel for such wonderful presentations. We hope to have you back again, and we appreciate the time and effort that you put into this.
And to all of our participants that have been online, thank you for your questions and your comments. Thank you for the support of the projects that have been described here today, and for sticking with us throughout this. We appreciate it. And now you've already got me thinking about what our next topic is going to be. So we'll have to do this again at some point. And but thank you so much. Coming from all parts of the world to join us today. Again, this was on behalf of the National Association for Court Management and the International Association for Court Administration and PRAVO-Justice. So we thank our sponsoring organizations, and we look forward to seeing you again sometime soon. And to our wonderful speakers, my heartfelt thanks. Appreciate it all.